Bill number 62, the people of the state of New York versus Natascha. Counsel?
Good afternoon, Your Honor.
Good afternoon.
Robert Lewis on behalf of the people. The people would reserve 2 minutes of rebuttal time.
Of course.
This case demonstrates precisely why the framework developed by the Second Department in People v. Hamilton is entirely inappropriate in the case of guilty pleas. In People v. Caldevato, this court held that 2 expert witnesses and the defendant's statements could not, under any proper standard of proof, establish the defendant's actual innocence. In this case, on the other hand, the appellate division inexplicably held that the defendant's self-serving statements, inconsistent with both her confessions and her plea allocution, supported solely by a single expert testimony, were capable of establishing her actual innocence. Clearly,
what's the standard for granting the hearing?
According to the appellate division, it requires a prima facie showing of the defendant's ability to establish by clear and convincing evidence their actual innocence.
And where is that in the statute?
It's not, Your Honor. It's not. That's precisely why the Second Department apparently found it necessary to develop its own scheme in terms of...
Well, it's also because it's not statutory, it's constitutional, right?
That was their holding in Hamilton, yes, Your Honor.
Right. What's your position on, are you only arguing for a plea line, that you're not arguing against the concept of actual innocence? Is that correct?
The concept of actual innocence as factual innocence?
Right.
Yes, it's certainly not unheard of that some defendants are factually innocent. In fact, in the case of guilty pleas, certainly defendants are factually innocent.
I'm sorry, my question wasn't clear. Would you agree that an actual innocence claim, a freestanding actual innocence claim, could be brought if there wasn't a guilty plea?
Yes.
And that's the position of the Fourth Department, I believe.
That appears to be the decision of all of the departments, Your Honor. The issue is not before the court.
So it's just the plea is a cutoff, is what you're saying?
Yes, Your Honor. Yes, Your Honor. This case deals solely with the defendant's guilty plea. The issue of the trial claim or the appropriate trial standard is not before the court. If the court, as a related matter, wants to address how an appropriate plea standard, which necessarily involves the fact of the plea itself, would be different from the trial standard, that's certainly up to the court.
Could we avoid it?
Certainly. Absolutely, Your Honor.
What would be the remedy for someone who pleaded guilty and subsequently had definitive proof that they were innocent?
A proper remedy, as with any plea remedy, would be the vacatur of the conviction. And
what would be the basis then for vacating a conviction?
It would certainly be covered under any meritorious claim of actual innocence would necessarily be covered under one of the statutory sections.
Like DNA? There's
Like
a DNA for a plea, right?
Yes, Your Honor. And the DNA is explicit, but even entirely independent of the DNA, a claim of innocence can certainly lend greater support to something else, although not an absolute necessity.
Ineffective assistance claim, perhaps?
Yes, precisely.
And there is one here? Is there an ineffective
There
assistance?
is, Your Honor. And it was, the defendant was provided a hearing by the Second Department, and that part of the appellate division's decision is not currently before this court.
What does judgment obtained in violation of the constitutional right of defendant mean in 44010? That's, the subcategory.
Just that, Your Honor.
What does that mean? No, well, what does it mean?
The defendants have a recognized constitutional right to due process, certainly.
So due process, what, in the trial or plea proceedings? Is that?
In all proceedings, Your Honor, certainly. Certainly.
And that's what it's limited to, is that your argument?
Yes, Your Honor. Yes, Your Honor.
Well, contrary to what the appellate division said here, right? Aren't they saying that that is the subdivision under which this freestanding innocence claim falls?
They are, Your Honor.
Okay.
They are.
So I'm trying to determine
The way that the statute is written, H is clearly intended to provide a fallback position to adequately cover a number of claims, such as ineffective assistance of counsel. In the case of guilty pleas, though, claims of actual innocence or any other due process claim are adequately addressed by sections such as 1A and 1B, 1D, I believe, which provides for instances in which they are not, in fact, knowing, intelligent, and voluntary for any number of reasons, whether it is, in the case of 1H, ineffective assistance of counsel, or an impediment to the capacity of the defendant, or in instances, we pointed to this court's decision in People v. Plunkett.
So let me just understand this line of your analysis. Is your point that if the grounds by which a defendant is arguing for the hearing based on actual innocence doesn't fit any of the other categories, but it's constitutionally based, then they can proceed on 1H?
No, Your Honor. Our position is that any meritorious claim of actual innocence in the
Yes.
instance of a guilty plea
Yes.
would necessarily, as a matter of law, fall under one of the existing categories.
It would never not fall under those categories.
Correct, Your Honor.
Okay.
Any
And this
meritorious.
one falls under which category? The
This-
ineffective assistance?
Yes. Yes. Insofar as the Second Department has stated that the defendant is entitled to a hearing on that issue, that is the decision.
Given the standard for ineffective assistance, if the court concludes that in this case that lawyer wasn't ineffective, does this defendant then have any recourse?
Certainly, Your Honor. Then the matter would be restored. The guilty plea conviction would be vacated. Indeed, that's the entire.
No, if the court determines that, given the standard that applies to ineffective assistance, which you must agree is quite a high one, that this lawyer, under these circumstances, wasn't ineffective, what relief would the defendant have? What recourse?
The plea would be vacated, and the matter would be entirely restored, as with any other involuntary plea.
I think, counsel, what she's saying is if you lose the ineffective assistance claim here, if the defendant loses, and now the conviction stands and the claim remains actual innocence, is there another avenue for this defendant having lost that motion?
If the hearing had been denied on the issue of actual innocence?
Or they go to the hearing and
on
they
the
lose.
issue of ineffective assistance?
Yeah, or they lose.
Then the evidence clearly wasn't sufficient to meet that standard and would not be sufficient to meet any meaningful standard.
Did they get an executive pardon? Perhaps?
Well, perhaps. But obviously, that would be a matter for the governor and not for the courts.
One of the problems analytically with the people's proposal, it's rational, but what I wonder is, are we creating two categories of convictions? One where you have certain rights.
Well,
let me just finish my thought. And under a jury trial, you'd have certain rights to challenge bring a freestanding claim of actual innocence if we went that way. But in a guilty plea, which we've never drawn a distinction between those convictions before, you would not have that right.
the way that the appellate division set forth its standards essentially necessitates that. It is, in fact, an equal opportunity.
You see the
In
next
instance of a-
challenge. You see the next challenge would immediately, I think, if I had someone who was a plea and they had a good argument for actual innocence, I'd say you can't create two different, that wouldn't be constitutionally, that wouldn't pass constitutional muster to do that.
This standard is the same in name only. In the instance of a guilty plea, the plea essentially does away with the need for
But you have
any
to
trial
address-
evidence. And in the case
Slow down 1 second. I just want you to address my question, which is, do you think we would be creating two different categories of convictions? And if not, why not?
you would not, Your Honor, because the standard that they claim to have applied is the same in name only. It needs to be two different, clearly articulated standards only insofar as it applies to everything underlying the conviction. In the case of a guilty plea, the conviction is invariably supported by the plea itself. In the case of a trial, as they identified in Hamilton, the issue is addressed to specific aspects of the case against them. Like in Caldevato, when the issue they attempted to raise was the expert opinion. Mm-hmm. In this case, there certainly was an expert opinion. There certainly were statements which the defendant has characterized in her motion. But ultimately, the conviction is based not on trial evidence, but the plea itself. And the plea itself must have the same weight and strength as the trial evidence. That requires a different standard than what they have identified in this case. If the standard in Hamilton is appropriate, then it is appropriate, but it must be a standard that is equal in implementation in the case of a guilty plea. This is simply not enough. And the failure to do that...
I'm not clear, then what should be the standard? I thought you were arguing it shouldn't be the Hamilton standard. What do you say is the standard by which to weigh that
The
guilty plea?
Hamilton standard they refer to as clear and convincing evidence.
Yes.
I can't give you a name for the police standard, but it certainly must be clear and convincing evidence plus, because in the instance of the clearly identified instance of DNA...
How about
if they-
overwhelming evidence of actual incident?
I cannot articulate the standard, Your Honor. It simply needs to be
hasn't it been
significantly higher
articulated in
so that the plea allocution retains the same weight and efficiency and absolute value as a trial verdict. Defendants are necessarily regularly told prior to entering their pleas that the consequence of a plea is the same as a consequence after trial. And if like
Let me
this,
ask you this, though. Would it be different if it was an Alford plea and you didn't actually have any factual allocution in the plea?
different in what sense, Your Honor? Alford pleas are regularly treated the same as any other plea. In the case of, in essence, in terms of the strength of the case against her, her motions attempt to impose a degree of collateral estoppel, essentially saying that some other civil jury rejected entirely distinct testimony addressing distinct issues from this witness, and therefore that shouldn't carry the same weight against her as it did in eliciting the guilty plea to begin with. Any appropriate standard would not allow for that sort of thing. And the fact that an Alford plea would involve a different allocution should not affect its weight. This court has regularly treated Alford pleas precisely the same as any other plea. There have been a number of cases in which defendants have entered Alford pleas and subsequently come back and moved to withdraw their plea.
Can I just clarify
In People v.
something?
Alexander. I'm sorry.
We're talking here about what the standard would be. That assumes that there is an appropriate available claim here, right? That a person can have a guilty plea set aside on a claim of freestanding, that's right?
If there were a freestanding claim, then the standard would be higher.
Thank you,
I would
counsel.
submit-
Thank you. Counsel?
Good afternoon. May it please the court. John Ingrassia, Larkin Ingrassia, Teppermeister, Newburgh, New York, for respondent Natascha Tiger.
If we recognize a freestanding, well, that's what we're all calling a freestanding claim under subdivision H, right? Then aren't we eliminating all of the specific requirements of the other 44010 grounds?
No, I don't believe we are.
Well, but if anybody can come in and say, I'm actually innocent, and here's my proof, whatever it may be. Maybe it's newly discovered evidence, maybe, maybe it's something else. And so I'm entitled to a hearing if I've met whatever the standard is, right? Then why would anybody come in and meet the requirements of newly discovered evidence, that it couldn't have been discovered before, and all of those things? What's the point of those?
I think the answer
Or
to that,
DNA or anything?
I think the answer to that question is multifaceted. Innocence, actual, factual innocence, is freestanding. And actual innocence takes the form of many different shapes and forms. Some could be exoneration.
But that's the point. The legislature has given us this very detailed scheme on what bases and grounds you can come in and prove that you were not guilty, that you were innocent. And that may be because your lawyer didn't do right by you, or there's DNA evidence to show that you're innocent, or there's other kinds of evidence that shows you're innocent. It lays it all out.
Well, I believe, Your Honor, in and of itself, an ineffective assistance counsel claim can be brought under 440-10-1H, which in this case, precisely what happened, but we also brought that application under 440.10(1)H as a freestanding actual innocence claim because the legislature does not delineate what type of constitutional violation has to be attendant with that proper motion.
Let me ask what I asked your adversary.
Certainly.
What does that mean, a judgment obtained in violation of the constitutional rights of defendant? To me, that says that something was constitutionally wrong in the way that that judgment was arrived at, not something that comes up afterwards.
So I would answer that question. There are many different forms of constitutional error. You could have a Brady violation where a prosecutor willfully withholds Brady material. I believe the Fourth Department just held about a month ago, I believe it was a Wilson case, I just read it this morning, that a failure to turn over a Brady material as part of a guilty plea survived that guilty plea.
Okay, and
That's one violation.
That's prejudgment,
Right.
though. I'm talking about the
Understood.
language of the statute.
But if we accept the premise, and I go back to my initial assessment, if we accept the premise that innocent people falsely confess to crimes that they did not commit, and even the DA concedes that in their reply brief,
All the time.
we
right?
also have to accept the premise that those very same factually innocent people falsely admit their guilt to crimes that they did not commit. And if that happens,
Yes, but isn't her whole argument here that the reason for that is because of the ineffectiveness of her lawyer?
I
Isn't
think
that really, when you drill down, that's why she says, I ended up taking this plea?
she took the plea because of her advice of her attorney, yes, but also because she was unaware of the existence of a pathology report taken from this child at
But
Westchester
doesn't
Medical
that
Center.
track back to failures of her lawyer?
Indeed, it does, but it doesn't have to be completely married with that. So hypothetically, if I may, this is just one example where you have an ineffective assistance of counsel also with a freestanding actual innocence claim. The two are not mutually exclusive. And nowhere under 440, I would respectfully submit, does a litigant, a defendant, a convicted individual have to choose under what theory. It might fit multiple theories. You have exonerated people for DNA evidence, exonerations through recantation, exoneration through newly discovered evidence, which I know
Counsel,
there's a
the-
definition.
counsel-
What
I'm
would you
sorry,
characterize this as?
If we use the term newly discovered evidence, this court has defined that. The CPL 44010 talks about it has to be after trial. Here, and I think we cite this in our brief, the evidence always existed. We don't know the reasons why it was not made part, and there's no bad faith here alleged on the district attorney's part. The materials turned over to defense counsel, the subpoenaed records from Westchester Medical Center, apparently just omitted the several-page biopsy, pathology report from the biopsy. Why that was omitted, nobody knows. And that's a separate
But counsel,
since the counsel
this
claim.
whole scheme goes to, the newly discovered evidence builds in an after-trial provision, and part of that is because by pleading guilty, you give up a lot of rights in exchange for this deal. And now the government has a guilty plea, and you have whatever arrangement you've made in terms of the plea and the sentence. You can wait 5 years, 10 years, government witnesses can die. They never had an opportunity to put their case on, and now you come in with what essentially, to me, seems like a freestanding do-over claim. Now I want my trial. And the government has never had a chance to put on their case, and 10 years later, you come in with, I have this pathology report, I have this civil testimony, and it seems the whole intent of 440 is to get away from that. So they do distinguish between pleas and guilty pleas and trials for that very reason. So in many ways, you give up many things when you plead guilty in order to get the benefit of the bargain. And that's reflected in this statute. And it seems to carve out an H as a freestanding actual innocence claim just gives you the right to wait after a guilty plea a certain amount of time and come in with material that doesn't even meet a newly discovered evidence standard, which you have to go to trial to get, and have essentially a do-over trial, the trial you forfeited.
I think, again, to answer that question, you have to look at the underlying facts of each specific case.
Yeah, but we can't do that. We have to, we will to some degree, but really, there's a quote from a case, Hansen, I think they said, the plea should not be used as a device for a defendant to avoid a trial while maintaining a claim of factual innocence.
That's correct.
I think that's what they said, and that's really, if factual innocence can survive a plea, then the very premise of guilty pleas, admission of the crimes, will be undermined, because what we're saying is the admission may be false. And we maintain that option all the time to say that this admission may be false. It seems to go to the very heart of our system. I mean, 97% of our cases are resolved by pleas. So you're going to say that all those pleas are not final, and they never will be final.
They are final unless and until they're vacated based upon a high standard
So
as
let's
set
get
forth.
there. Let's assume we're there. Since there's no trial record when someone enters a guilty plea, what do you propose? How does the 440 court examine and compare and weigh the conflicting testimony? What does the court do?
I think the court would actually have to hear evidence. Obviously, the defendant,
A new trial? Is that what we're doing?
there would be an evidentiary hearing. The defendant would actually have to present evidence of a high caliber, of a clear and convincing nature, which is a very high standard of proof. And let's not forget, the district attorney's office will have the right to confront, to cross-examine any evidence that the defendant puts forth.
And what's the standard?
Present-
What's admissible at that hearing? Does anything go?
I believe any type of relevant evidence would be admissible. That's a question I actually hadn't thought
What happens
of.
at the end of the hearing?
I'm sorry?
What happens at the end of the hearing?
The judge would have to make a determination
Of what?
of whether the
Whether-
defense has met its burden by clear and convincing evidence.
To what? To get a trial, in this case, not a new trial, but to get a trial,
Well-
to go
So-
back to the pre-plea status, or what?
Under-
What would the remedy be? Would you dismiss the indictment, or would they get a
It
new
would be a
trial?
dismissal of the indictment.
That's
under-
what you're seeking?
Under Hamilton and
So
Tiger.
essentially, you've pled guilty, okay? And now you're coming back and say, but I'm really not guilty, and here's my proof, and I have to prove that by clear and convincing evidence. I don't have to prove it to a jury, there's no jury here, there's a
Correct.
court, right?
Correct.
And so instead of the trial that the people were entitled to have, and you were entitled to have, we're going to have a bench trial based on clear and convincing evidence. How is that fit within our system?
I think it fits within the system because this court has held time and again, if you go back to the forfeiture doctrine and what is waived and was not waived, claims relating to the integrity of the criminal justice system are not waived. And I would respectfully submit.
Well,
there could
that may be, but that doesn't mean that we wipe the slate clean and we have a whole different basis for determining guilt or innocence.
When
No,
the
I-
government hasn't had a chance to put their proof on. So at least if you have a trial, you're weighing what the government proved beyond a reasonable doubt against this material you're going to produce at a hearing. Here, witnesses may have died in the interim, maybe 10 years later. You waived all of that, and now you're coming in and saying, I want a clear and convincing trial so I can prove that the indictment should be dismissed.
If it were a multi-count indictment and the defendant pled guilty to one count of the indictment in satisfaction of all the charges, what happens to those other counts? Does the people get a opportunity to?
I would suggest if all the counts relate to the actual innocence that's being proffered, then the indictment would be fatal. However, if there's counts that are separate and apart but joined in that indictment, then obviously those counts where actual innocence has not been established would survive, and the defendant would be brought to trial in that regard.
And the prosecutor would be trying that case 5 years later, 10 years later, whenever it was?
Depending on the facts, but if there's no actual innocence in that regard, then yes, that would be the case.
So if we disagree with you here about the way she might present this claim of actual factual innocence, she still has the ineffective assistance claim.
Oh, she does.
What would be the different, let me say this, let's say there's two separate hearings. What's the difference in evidence at these two different hearings?
Well, ineffective assistance would be the defendant's burden by preponderance of the evidence. The actual innocence claim, freestanding, would be this clear and convincing. In this case...
But I'm saying, what would be presented? Is there something different that is going to be presented? Again, because as I understand her argument, this all falls on the failings of her lawyer.
In this case, I think the two claims are married, and that the pathology report that was never secured is, in fact, the ineffective assistance of counsel. I would lastly point out to the court that if, in fact, and I think, Judge Stein, you asked Mr. Middlemas this question, if there is no statutory relief for a factually innocent person to bring a post-conviction remedy adopting the district attorney's theory, then as I see it, there's only two possibilities. The first is through a prosecutor's conviction integrity review committee to review. The second, through some type of executive pardon or clemency. Neither one, however, is subject to any type of judiciary review. And given the fact this court has held time and again...
See, but this is why I keep having problems with your argument, because doesn't she have that ineffective assistance claim? I mean, there are other defendants who argue ineffective assistance and may very well also be taking the position, I am innocent, but they're focused on that ineffective assistance claim. And I'm just not clear how this particular defendant or someone in her position would not find appropriate recourse through that type of relief that's already provided for.
She does have recourse. I go back to my argument, however, that 44010 does not limit the type of recourse that's available to any type of defendant.
But what about the fact that we and the Supreme Court have held that there's no constitutional right to any appeal or any collateral attack on a judgment or conviction? So how do you get beyond that to say...
You get beyond that, I would respectfully submit that a factually innocent person is subjected to due process, cruel and unusual punishment violations because they're innocent has to supersede. And this court consistently said that any type of errors or claims dealing with the integrity of the criminal justice system is not abandoned or waived by a guilty plea, the forfeiture doctrine. And I would respectfully submit, in our age of exoneration, Chief Judge DeFiore's bold proclamation regarding new orders to counsel. Every new time I get a case in arraignment, we get those new orders to counsel. It recognizes that this is epidemic. False confessions exist and innocent people.
But that goes to the process leading up to the conviction, doesn't it really?
But it doesn't end, Your Honor, based upon. I would ask this
But
question.
see, here again is my difficulty with that. Trying to respond to Judge Stein, I thought your argument and what you briefed and the position she's taken is, yes, there's a due process violation, but you're also arguing that she's denied her constitutional right to counsel through this ineffective assistance of counsel claim. But since there's already a mechanism by which she can present that, she can't go through H. Is sort of my response to that. That's, again, why I don't want to be redundant here with this questioning, but that's why I'm having difficulty with your position.
Understood. I think put another way, perhaps, my reading of the district attorney's arguments, specifically in the reply brief, is that if a person pleads guilty, they may have a freestanding actual innocence claim, but it first has to fall under either some type of fraud or duress on the part of the court or the prosecutor in inducement of the plea, DNA evidence exonerating, or ineffective assistance of counsel. Maybe I'm misreading that, but that was my take on it. My position is, as I said in the beginning of the argument, is that innocence is innocence. It takes many different facets. It could be witness recantation. It could be false identification. It could be a Brady violation. It could be a multitude of reasons. It's freestanding and it's actual innocence. And I would submit that if a person, I asked myself this question this past Sunday afternoon as I was preparing for this argument in my office, if an innocent person, an actual factually innocent person pleads guilty, are they actually guilty or are they innocent? In a legal sense, they're guilty. They've been convicted. But in an intellectual, de facto sense, they are innocent.
But if you have conflicting expert testimony, if you have recanting witnesses, all of that has to do with credibility and a whole host of human things. How do we ever really know if somebody is factually innocent? I mean, and I mean, didn't the Supreme Court say in Herrera versus Collins that due process doesn't require that every conceivable step be taken, no matter what cost, to eliminate a possibility of convicting an innocent person?
Indeed. However, with that, I don't believe this case is a case of dueling experts, contrary to what the district attorney says. In fact, in the civil case, there were no expert witnesses presented by the defense, and a unanimous civil jury found, despite hearing evidence of her confession, despite hearing evidence of her conviction, and being instructed.
Dr. Turkowski testified in the civil case.
For the plaintiffs, correct.
Right.
And the jury, no cause, unanimously.
Right, so that would be against the defendant then. Turkowski gave the same theory, I'm assuming, that he did.
But the jury rejected that, is what I'm trying to say. And the
That's
defense
correct.
did not,
Right.
my understanding, the defense did not call any witnesses. But again, we have the pathology report that shows a diagnosis of toxic epidermal necrolysis. All of the original differential diagnoses by the 5 disciplines, emergency medicine, pediatrics, infectious disease, dermatology, and burn services on initial entry.
Counsel, all this could have been fleshed out at a trial. And when you say before you could have a recantation of a witness, again, when you have a plea, if you didn't have a plea, the people would have put on their case. They would have called that witness. They would have locked in testimony that you could have cross-examined. And then if later that witness recants, you have that entire record. Now, a witness who doesn't have to go through that, and it may be a witness who doesn't really want to testify, but it's the immediate aftermath. They go, they testify. Now, later, they feel bad about having to do that. They recant. It's harder. You don't have that testimony. You have a plea. Later, they say, you know, I really wouldn't have testified to that. I didn't really mean that. Now, where are the people? They haven't had an opportunity to call that witness. That witness had, what are you weighing that against? And that's why this statute, to me, makes that difference between a plea of guilty and someone who goes to trial. Because what are you weighing these things against? 10 years later, someone recants and a people's witness is dead, and now you're going to have this clear and convincing hearing? I don't see, again, going back to where does that fit in this entire process? That you get this kind of freestanding, clear and convincing hearing 10 years later after you've admitted guilt under oath.
Again, each case is individual, and I would respectfully.
We can't make an individual rule here, and everyone will be actually innocent until they get this hearing that says that by clear and convincing they haven't.
No, well, they're not actually innocent until they're proven to be.
Say they are.
Well,
We don't say, well, you're actually innocent, so you get the hearing. You're going to come in and have the standing to get a hearing by claiming this, right?
Correct. Correct.
So that opens the door. We're not making a rule for only the people that really are actually innocent.
Well, I would submit, Judge Garcia, that in that regard, the trial court will be the initial gatekeeper as to.
So they'll decide who's actually innocent, so they get a hearing to determine if they're actually innocent?
No, it could be. In our case, Judge Barry denied us a hearing. We sought leave on a 440 denial to the appellate division, granted leave, and that's, you know, the sequence we got here today. So the courts are free to deny an application if there isn't a sufficient factual showing in the moving papers. Again, I know I'm being redundant here, but when you ask the question that you just posed, and it's a valid point, I certainly concede that, freestanding actual innocence has to take priority, we would respectfully submit, because it's any type of conviction that's constitutionally infirm has to be afforded some type of collateral attack, even after a guilty plea, because it goes to the heart of the process.
Thank you, counsel.
Thank you
Counsel?
very much.
You're welcome.
That's an excellent point, that the plea defendant should be afforded an opportunity to come back if it goes to the heart of the process. In fact, they are. They are, by specific sections of CPL 44010. Defense counsel mentioned Brady violations a couple of times. If you had a Brady violation that induced the guilty plea, that would certainly provide the defendant a cause of action under 44010-1B. That could easily be a misrepresentation. People v. Sieber from the 3rd Department involved a DNA tech who did not properly perform the testing.
What
And
would,
the
what
people-
would be her argument, given this particular factual scenario? What would be her argument that her plea is not voluntary?
The defendant has clearly argued ineffective assistance, that the failure to adequately appraise the strength of the case on the part of defense counsel will provide her a hearing. The Second Department has agreed with that, for whatever reason.
So you concede that as a potential ground?
That she is entitled to a hearing on it, on the ineffective assistance claim? Yes, we're not contesting that issue. That is the decision of the
No,
appellate
that
division.
if indeed the attorney is ineffective, as they have described it, that would result in
That would be
success on the claim that her plea was not knowing voluntary.
If the attorney were ineffective, if she could establish that the attorney was ineffective, yes, that would demonstrate that like any other ineffective assistance of counsel claim. That's why it adequately provides relief, because it's just the same as any other claim. And I wanted to
Counsel, let's talk about for a second newly discovered evidence in the context of this actual innocence claim for a person who has pled guilty. The guilty plea was constitutionally obtained. She was properly counseled. We're not talking about DNA evidence. Is there any hypothetical that you can think of where that person who develops newly discovered evidence after the guilty plea that proves that she is innocent would...
The legislature has identified a single instance, DNA. The legislature has...
Let's not talk about DNA. Let's talk about the person who is misidentified as the perpetrator of a crime. Based on that, he or she pleads guilty to the crime, is sentenced, and then 5 years later, someone comes forward and says, I was at my window, I videotaped the whole crime, you got the wrong guy. Here is the videotape of the actual person. What do we say to the person who pled guilty based on the misidentification and now is incarcerated? Do we say?
Thank you, Your Honor. I think Sieber is an excellent representation of that instance. In the event that solid evidence comes out later, it is entirely possible that it could be determined subsequently that it amounted to a misrepresentation of the case. I think if you have an expert who absolutely...
Misrepresentation by who?
The word intentional does not appear in the statute. The word intentional does not appear in the statute. People v. Sieber in the Third Department involved an instance in which there was a problem with the technician that the people were not aware of at the time, but it affected the voluntariness of the defendant's plea. That is entirely understandable. It obviously cannot be said. Common sense says that does not.
I thought you would have argued if it's newly discovered evidence. Is your position that what the judge has described is evidence that could have been discovered with due diligence? Otherwise, doesn't it fit the newly discovered evidence provision?
In theory, that could fit the newly discovered evidence provision, but it is two fundamentally different instances. It is two fundamentally different instances, primarily because in the case of newly discovered, it would be the same in the sense that both could be potentially entitled to a new trial because the only relief would be to vacate the plea. But it is fundamentally different in the sense that there could well be a lot of newly discovered evidence that would have made a potential difference in the trial, because that is the standard for newly discovered evidence. And in the case of a guilty plea, evidence like this, an expert testimony that's inconsistent with another expert testimony, cannot possibly establish by any meaningful standard actual innocence. Whereas videotape testimony, certainly DNA evidence, fundamental flaws in the people's evidence, certainly could impact the voluntariness of the plea. It could amount to a misrepresentation. The word intentional does not appear in the statute. That would provide a form of relief. And the relief would be the same as any other proper post-plea 440. The matter would be restored as it was before, not absolutely vacated, as the Second Department has inexplicably decided would be appropriate in cases like this.
But indeed, I understand your position here. You think the evidence doesn't show actual innocence. But in the hypothetical about the video, that does indeed show that someone else committed the crime. You would agree that the prosecutor would not proceed with such a case, correct?
No, Your Honor. It would depend on the facts of the individual case. There are several instances in which it would still be worthwhile to proceed.
What would that be?
If you had a defendant, the one issue in particular I wanted to get to and address was the significance of the superior court informations. Instances in which the defendants entered into a plea to a single crime to satisfy whatever was charged without an indictment, so that the evidence is not even presented to a grand jury. In those instances, they've been convicted of one single crime based on one single accusatory instrument. In instances like that, it is entirely possible that if they could produce evidence that demonstrated that they did not commit that crime, they certainly would be unable to produce evidence that they did not commit the additional crimes that covered. But if it occurred well after, it would be beyond the statute of limitations, and they could not be prosecuted for the other crimes that they clearly and potentially undisputedly committed. Similarly, if it was a single criminal transaction, let's say the defendant was prosecuted for an assault, for shooting someone. If it came out later that there was a videotape that showed that they were not the actual shooter, but they still possessed the gun, that clearly is a crime, and they certainly should be prosecuted for that, regardless of whether or not they pled guilty to it in the first place.
Thank you, counsel.
Thank you.